All right, I'll just start the recording. This is LAWS12059 Conveyancing, and we're doing topic 9 on special conditions. Look, this is really, for those listening to the recording here and those travelling elsewhere to more interesting places in the world. This is a really important topic, I think, in this whole course. It's important from a number of perspectives. It's important because it's an area where the legal practitioner is actually being required to bring their skills and their understanding to bear in actually doing something that's can be and probably should be or have aspects of originality in it. I mean, in practice context, of course, one tends to look at precedents and so on and so forth. But as we will see when I refer you to the Tallwoods case, the judgment of Rob there from the New South Wales Supreme Court, one has to be very careful in using precedents. And one needs to look carefully at the situation, the whole of the facts and what the client wants, seeking to achieve, and then it befalls the practitioner to stand up and do what's required in terms of preparing and drafting a special condition to contract of sale. So it also brings into play your drafting skills, which you specifically develop somewhere else in your program, but they come specifically into play here, just as they do in many areas of practice life. And practitioners, in my view, should stand up to these challenges and meet these challenges and do what's required, rather than constantly sending off things to counsel or whatever when there's any slight area of complexity or slight extra rather than just process type work. You are legally trained, you are legally qualified, you have capability and should be able to undertake these things. So drafting is also critical, and it's a skill, a capability that's being tested and applied in the context of thinking about this topic, not just the legal element, structure and the legal, what the case law says. So it's a very practical thing. Second, another aspect here is that because mostly, of course, we're working with standard form contracts, the 3 different versions as we know in Queensland, then we have to ask questions. As I know you have, Grant, I know you've responded to this aspect in your answer that you posted on Moodle, which I've given you some feedback on, and others. Lisa put up a response as well. You have to look at the standard provisions within the standard contract of sale and ask yourself whether a special condition is needed. That's the first question. We don't just, run off and draft one up for the sake of drafting one up. So it requires careful understanding of the context and the import of the standard provisions. But, we must be mindful that if we need to address this through a special condition, then we need to add it into the contract, and it enlarges those standard provisions. And of course, our drafting skills will hopefully have taught us that we need to use good, plain language, straightforward language, do away with all the legalisms and all that sort of thing. So this topic has, both implications in terms of understanding the law that underpins the area of special conditions, the types of matters that arise with respect to special conditions. So, for example, on page 15 of the notes, very typically in contracts of sale, there are special conditions around finance, around inspection or building matters, regulatory things like in Queensland, pool safety clauses, for instance, local government issues, rezoning issues, and one has to be abreast of current developments and what's going on there. And as we've seen with the discussion in issues paper in relation to seller disclosures, reforms in train, implications of local government doing things that are adding further layers of obligation, which were documented in those reports. And then lastly, of course, which comes up in the problem question, one of the two problems today, subject to the sale of another property. Came up in another context too, but we'll leave that for now. So, you know, there are some standard areas where this arises. And then, you know, we need to ask, how do we tackle this issue of thinking about terms and conditions, special conditions? And in my view, it's the best way to tackle it, just like in any area, is to focus on substance rather than form. That is to ask, what is the intention of the client or of the parties? What is to be achieved as a matter of substance? And then insofar as it proves necessary, we then need to satisfy form requirements. So what I'm striking at here, of course, is the relevant nomenclature that we need to be thinking about or relating to, and of course, thinking about a condition, we characterise it as a certain way, as a condition precedent or a condition subsequent. When it subsequently gets interpreted, how relevant, how important or important is that today, rather than focusing on the substance of the clause. And something that comes up in, I think, not necessarily in Rob's decision in Torwoods, but certainly in his College of Law discussion paper, where he does refer to his decision in Torwoods, is the mindset of the draftsperson. That is, does the draftsperson have a mindset at the time when they're drafting up this special condition, not just about what's going on at the time when they're doing it, but in anticipation of disputation between the parties, and that this will be challenged through legal process. So there's a challenge that's laid out to draftsperson and to practitioners doing the drafting here in terms of getting their head around what they need to do and how they need to do it. All right, so without further ado, let's proceed on to the questions, problem questions, and problem 17. Sir, you're the only one here, so I have to call upon you.
Basically, the question is asking whether, I guess, the terminology condition precedent and condition subsequent is relevant today, as thrown up in the, I'm not sure if this is the correct pronunciation, Meehan versus Jones. Which, in actual fact, I found there was not a lot of discussion about it in that case, but one of the cases they referred to, I found quite interesting, which was the, what was it? Perry, the Coolangatta Investments.
Yeah.
And so, essentially, obviously this is a critically discussed question. It was trying to support whether those terms are, how relevant are they? Are they still relevant, or are they not relevant anymore?
And what's your view?
I see them as labels.
Yeah.
And to me, they're a label of a conclusion. They're not sort of a label of a process. They simply, to me, that's the outcome. A condition precedent is that if the intention is there that the terms of the contract in any form are not going to be followed unless an event happens that brings that into existence, then that's a condition precedent. It doesn't come into effect.
But the point here is, I agree with that. I agree with that. And I'm most likely going to agree with what you say with regard to the second characterisation too. But the point here that do we presuppose our interpretation and rendering of the clause by its classification through this sort of process?
I think on the facts, if it may present that it looks like if the party's intention was that they don't want to proceed with the contract unless that event occurs, well then that straight away, I guess, channels you down the direction that it's a condition precedent, and you can try to follow the case law that supports that.
Well, this is the point, isn't it? This is the point. The point is that the way we should be approaching it? That is it that we should be looking at saying, oh, well, you know, this looks like, feels like, smells like a condition precedent, and so this is what the law says on condition precedent, and it doesn't tick all the boxes, so guess what? It doesn't satisfy the requirements of being a valid and enforceable provision because, etc., etc., right? Is that the way that we should be approaching the interpretation and the reading of a special condition in a contract of sale?
I don't think so. I think that...
how should we do it? Tell us how we should do it.
Well, it comes back to how the question was prefaced, which is that you're looking at the intention of the parties. It's the parties have entered into a contract, or they have an intention to enter into a contract. Either way, they're making an agreement. They've reached an agreement that won't come into effect until something happens.
Yep.
So it's establishing their intention. Do they intend to be bound by that if the event happens? So they intended to enter into a conditional agreement.
Yep.
So to me, contract formation has already occurred. Yep. And that's, I think, the underlying argument that the courts were saying as to why the labels become irrelevant, because they've already proceeded. They've formulated a contract.
Arguably, that's right, I agree with that. Arguably, those labels are less relevant today in any context. You know, I don't hold myself out to be a full-blown contractual contract lawyer, but have chanced my hand a bit in various ways. Arguably, those sort of classifications are less relevant today, where in all situations we're trying to work out what this thing means in substance and how it should function and whether it should be enforceable and whether it works, rather than trying to fit it into a classification and then say, oh, well, these are the things you've got to satisfy. Because the point is, these classifications evolved just almost like what I would call a mechanism of convenience to enable to better slot things around and whatever. And this is the problem the common law always has, is that, you know, it starts to get firms up over a period of time and things get a bit more tight within categories and whatever. Whereas we should always be, in my view, going back and looking at the thing in substance rather than looking at the context, rather than looking at the form in which it's created or how we might label it and so on and so forth. Good point earlier you made about labels. Not relevant. Labels are not relevant. Doesn't matter. We call this something, doesn't matter. What is it in substance? We know that. We know the law looks to that in all things. Doesn't matter what we call it. What is it in substance? But the classifications, whilst in my view in a former time might have been more helpful, or, you know, while things were developing at an earlier stage, quite frankly, I think today they can be unhelpful sometimes, because they can lock you into a stream or a tunnel of thinking about something and not letting you see it, you know, in a wider situation. But so that's one aspect of the question. There's another aspect of the question which actually I think picks up on. I broke this question, you know, before, long before, you know, Robert delivered his paper, Justice Rob, and that is the whole point about what the environment within which the clause is being drafted, and what is being looked to when the clause is being drafted. So, just can you respond to that, Grant? What is the context, and what is looked to when the clause is drafted?
At the risk of repeating what I said before, it's the intention of the party. It's what mischief are they trying to either protect themselves for or provide for in the special condition.
Put yourself in the shoes of the practitioner / draftsman, right? How are you going to approach this? How are you going to inform yourself of what you need to be informed of in order to draft this special condition?
To draft the special condition will be to understand what the client needs.
Right. You going to ask them some questions?
Yes, absolutely.
About what? About what?
Well, it depends. It depends on the purpose, whether it's a subject to finance clause or a subject to the sale of a prior property.
Yep.
It's to understand what the implications are and the consequences, and how to draft a provision or a condition that doesn't bind them to proceeding with the contract unless that condition is fulfilled. So it's understanding what it is that the customer wants. What do they need? What do they need to achieve? Client.
That word more than once. Be careful. I know. I suspect you're moving between professions, so be careful. Anyway, that's right. Yes, that's right. I agree with that. Let me just, a bit of a leading question that I'm happy to do it in this context. Are you going to want to inform yourself of what I might call the surrounding circumstances?
Well, isn't that the mischief? Isn't that sort of the the details of the property that they're purchasing, what they're purchasing?
Basically, you want to know as much as you can about what's affecting what they want to achieve. Is that right?
Yeah.
Yeah. And you'll be picking up on that from what they tell you and other things that you might view and whatever, and then you're trying to reduce that as best you can into words that capture what they're trying to achieve and what they're intending between each other. Yes?
Yes, absolutely.
And then depending on who you're representing, whether it be the buyer or the seller, of course it'll have a particular slant, but hopefully it'll have a bit of a balance as well, because if it goes too far in the direction of if you like, in quotes, biasing one party and totally not recognising the interests of the other, then that'll be hopefully resisted by your colleague on the other side. Now, this is the point that I wanted to get to, right? So, yes, that's what a draftsman you would think would do, any reasonable and intelligent draftsperson would do. Are they, when they're drafting up the provision, though, are they completely focused on that situation at the time when they're drafting it, or do they also have a contemplation of how this clause is going to work in circumstances of dispute at a point of remove in terms of time?
Well, you have to have the consequences in mind, because you're drafting a provision to either avoid those consequences or to have those consequences imposed on the other party, depending on what the condition is to achieve. So you have to think about what its purpose and what you want to get out of it should the event happen or not happen.
Having said that, you'd be surprised how much a transactional lawyer doesn't contemplate the circumstances of litigation. So that the world of practice, in clinical sense, gets divided between transactional work and litigation, basically. And there are colleagues who never set foot in a courtroom or involved in a disputation process. Their work is transactional, and they are dealing with clients, they are dealing with their matters, they are drafting up things, but they're never involved in the disputes or problems or court. Right? Then you get others, that's all they do. They're only involved in that end of the process. Problems, court, disputes, resolving them. Right? Sometimes, of course, as we know, in the popular imagination, that's the more jazzy end. And certainly, in terms of the small screen, we see lots of that. We never see too much of the work that lawyers do in transactional context, even though that's actually the lion's share of it, in truth. Okay.
Is that inherent in the system of having either, lawyers have to choose? They have to choose to be a solicitor or they choose to be a barrister.
Mm. Well, in some jurisdictions, they're admitted as both, of course. And no, in some jurisdictions there is fusion of the profession. We have fusion of law now, of course, law and equity, but we have some jurisdictions there is fusion of the profession, so that the circumstances of practice in New South Wales and Victoria, mostly, is not replicated, a little bit Queensland too, as well, is not replicated in every jurisdiction in Australia. Having said that, there continues to be, in many places, separate bars, separate advocates, separate groupings of advocates that spend most of their time doing that sort of work in court or in similar type situations. I think it is a part of what's going on here, because historically there wasn't that degree of distinction. One goes back far enough, there wasn't that degree of distinction, right? And there was in some areas, but not necessarily in all ways. And I think it does in part explain that. But the lack of working across these areas also, I think, then explains the mindset. And this is one of the points that Rob tosses up in his College of Law paper, that the draftsman isn't anticipating the problems and how the clause is going to be sought to be applied in a dispute environment. That's not anticipated in the wording of the clause. The other thing that comes up too is, and this is why I was trying to tease out a little bit earlier in your response about the draftsman is informing themselves about, so the draftsman has had that benefit of doing that. But when the matter comes before the court or there is a dispute, which is when the rubber hits the road in terms of whether this clause stands up to scrutiny, of course there's none of that. There's no surrounding circumstances to be considered. You've only got the words on in the contract to examine and the intention as expressed therein. So if there hasn't been any anticipatory thought in terms of how the intention's been captured through the words in light of disputation, this can create some issues. Yep. Did you want to say?
Yeah. So that's the draftsman who is taking his best interpretation of information that is given to him to try and project the will of the parties. Something I was going to touch on was the fact is a contract is, there are two parties involved, or at least two parties, but there are basically two parties involved. One party may want a special condition.
Yeah.
The other party may not want that condition, or they may not want it in that form. So there's also going to be a negotiation between the two parties, potentially. So there may be a weakening or some revision and negotiation in terms of that condition so that both parties are satisfied. They may have to compromise.
Yeah, no, that's quite right. And you would hope that such clauses, not always the case, of course, but you would certainly hope that these clauses are the consequence of application by representatives on both sides of the equation, the seller and the purchaser, or the vendor and the purchaser. But that doesn't always occur. But you would hope that would be the case. See, I just go back, and you can just make a note of this if you haven't got it open, and I'll have a look at Meehan and Jones in a sec, but just go to Rob's paper, and it's about page 7, and I think I mentioned this in the last class, 7 to 8, 6 to 7 to 8. He talks about the idea of English expressions, and he talks about the mutability of English, and he talks about depending on the subtleness of context. And then he says, this is on page 7 of the paper, the draftsman prepares the contract in the context of its inception. The parties argue about its proper construction, and the court decides that issue in the context of a dispute before the court. They are often fundamentally different, and there is reason to suspect that the draftsman is understandably nonplussed when presented with the construction arguments that are put at the trial. So, of course, in the context of disputation, we don't have the conviviality of agreement in a general sense of working together. What we now have is a hostile position between the parties and trying to eke out of this clause as much as they can for themselves. Well, that's going to lead to a very different outcome and a very different reading of the language and the words than in circumstances of conviviality, mutuality and agreement in terms of how we came to this position. And that's not something I think that one can forget. It's an interesting observation that his honour makes, actually, in that paper. If we go back to Meehan and Jones, you got that open, Grant? Or can you get it open?
Yeah, I'm just going into it now.
Yep.
Open.
That's good, very good. I'm just... So, for example, just looking at the nature of the special conditions, right, looking at the judgment of Gibbs, the judgment of Mason is probably more commending itself, but nonetheless, Chief Justice's judgment should be acknowledged, I suppose. Anyway, in this context, in paragraph 8, he says, if the words of the condition are understood to import a subjective test, if the condition is fulfilled, if the purchaser honestly thinks that the finance is satisfactory, because of finance clause in the context of Meehan's case, it's impossible, in my opinion, to regard the condition as uncertain. The question whether the purchaser does think the finance clause is simply a question, does think the finance clause is simply a question of fact. In most cases, it will be a question easily answered. If the purchaser thinks the finance is satisfactory, he will normally seek to complete the contract. This goes to the point about the issue about whether the clause is clear and certain or not, or uncertain. And as your text points out, on page sort of page 409 to 410, that since Meehan's case, the clauses of nature, particularly finance clauses and some others, should not fail for uncertainty, but mostly they should continue to adhere to the contract and be seen to be valid and be clear and certain, even though certain form of wording has been used. The other point, which is picked up over on page 411 of your text, it was clear, this is second sentence on page 411. It is clear from the High Court's decision, that's in Meehan's case, that a court should be loath to find a clause uncertain, and the court would use extrinsic evidence to interpret and give meaning to the condition. Well, that's good and well, that the court will seek to have access to the extrinsic evidence, but how will the parties be seeking to interpret the language in circumstances of dispute? The other point there also picked up on with regard to uncertainty is that the courts will seek not to find the clause uncertain or void for uncertainty because they want to give effect to the intention of the parties. But the draftsman can facilitate that all the better by having an anticipatory understanding and a forward-thinking mindset when they're actually undertaking the drafting process. That the only time when this clause is going to come under the spotlight is in truth in circumstances mostly of litigation. Because otherwise, if they're all, parties are happy with it and it's there and they've agreed to it, there's no issue. And so that's the sort of two sides of the foil, in a sense, or two sides of the sword, Can you comment on that?
Is it fair to say that the purchaser may well want a finance clause to be ambiguous so that if it is subjective, it's to their satisfaction, then it gives them that additional sort of right or method of simply saying if they want to withdraw for any other reason, they just say, well, I'm not satisfied with the terms and conditions or whatever the case. Mm-hmm. So it certainly, when you now talk about drafting, to take away the subjective test, because you're talking about honesty, and in a dispute, just an observation, I think people's interpretation even of their own behaviour in the past sometimes changes as it suits their present argument. That to draft every possibility would be extensive, because you would have to draft out, for example, what is going to be to your satisfaction. So is that the interest rate, the type of financial institution? There could be a whole laundry list of things that you could go through. So it certainly would be possible, but then it almost seems that I think many purchasers may want that subjective test in there so that they have an easy way to get out of the contract.
No, that's good. You've picked up on precisely one of the features here, the guile, if you like, of parties, and the practitioner is running between these lines. It's probably too strong to say the avariciousness of the client. One can't really say that, but the self-interestedness of what, for example, as you mentioned, the purchaser wants. But one's skill as a practitioner, as a draftsperson, is to craft the language of the clause that captures some of that. But it's almost nonsensical to go into all of that detail, and ultimately would be a bit self-defeating actually. But does it in a way that gives the clause, if you like, an ambulatory capacity, if I can put it like that. Now if one can do that, that's skillful and clever. The problem that arises if we cut back into reality land and out of this interesting intellectual land, right? Cut back into reality land, the problem that arises is in the cut and thrust of practice, where there is limited time, pressure from clients, easy today, particularly with technology, very easy access to precedents ad nauseum, very easy just to, and there you go. The careful, thoughtful approach has been swept aside, and all of what we're talking about in the cut and thrust and in the pressures of daily practice situations just evaporates. So we can't ignore that. We can't ignore, in my view, the realities. That would be silly, foolish, and to be looking at idealism. But we've got to somehow get a bit of an accommodation here. That's all I can't put it any more highly than that. An accommodation between the importance on giving drafting a fair shake and what the client wants, and having a fair go at it ourselves. You might have some precedents around. There's no issue, no problem with that. But you're attending to what the client wants, seeking to work out the intention, and then formulating the words. And also, I would suggest, obviously, making it as clear and as certain as can be made, but also being mindful that at the end of the day, this is likely to be interpreted in the context of litigation or dispute. Just turn your mic off, Grant, when you're not speaking. Just background feedback. Yep, thanks. So that's something that has to be remembered. And as you know, and you've brought it up yourself, which is entirely appropriate and rightly so, ethics is never too far away, lurking in the in the crevices. That's one point, and that's almost been a carrying call in our discussions. But on another note, we're now operating in e-technology land, right, out there in reality. So everything's been speeded up. And both in terms of the processing and in terms of how things can happen, but also from the client's perspective. They can, and they probably will, be using technology to try and speed up the process, speed up the pressure to get things happening, right? And all of this has potentially a deleterious effect on the careful, thoughtful process, reflective process that needs to be brought to bear with regard to drafting of clauses, provisions, special conditions, whatever. That doesn't mean you need to spend weeks on this or days on this. You just have to get a balance here. But you have to remember that is a skill that requires your serious focus for however long you feel you can attend to it. That's what we're talking about here. And that is something that you will acquire over time, but it will not have the chance to develop and mature unless you practice it. There's the rub. Okay, so unless it's practiced, you don't get better at it. Okay, so anything. So I mean, that's so basically. Question 17 was about exploring those dimensions, getting you to think about substance over form. The relevance of, more historical classifications, and where the focus should be, and how you should think about the drafting up of special conditions in contracts of sale. Anything else on that, Grant, that you wanted to?
No, I'm happy to move on to the next question.
Move on, sir. Good. Let's do that. Move on to problem 18. Problem question. We'll have a go at that one.
All right. Alex has been through a separation with his partner. I mean, some of these details are not particularly relevant. They may be in terms of understanding the overall situation, but basically this is about acting for Alex, who is expecting settlement on his existing property in 4 weeks. The cooling off period hasn't gone through yet on that particular contract, so there is still some uncertainty. He has found an alternative property that he wants to buy, and obviously he has concerns about finance, and he needs his existing property to settle so that he has funds to pay for the new purchase. So he's looking for advice on either the existing standard provisions, whether they're satisfactory or whether some special conditions need to be drafted into his contract. And
so far, so good.
So essentially, starting with the finance provisions or clauses in the standard clause in the contract, Alex is saying that he has already applied online with 2 banks. One has already come back with an approval. The first thing on that is obviously an approval to an initial application. Banks don't usually loan on that approval only. There are normally terms and conditions. They'll want to, ensure that it's a valid property, that they're going to get title to it, or they'll be able to.
What do we call that approval?
Pre-approval.
Oh, we can. I was going to say approval in principle, but that's all right. Pre-approval's all right. I mean, it's just basically, saying the financial organisation is saying to the prospective client, or might already be client or customer of the bank, you can call customer in that situation, that this looks okay. Yes, looks like we would, be happy to proceed on this in general terms, but it certainly does not constitute a loan, and it certainly does not constitute a firm undertaking by the bank that they will extend the finance, and they will then subsequently need fairly substantial documentation of the customer's financial circumstances before they make their final decision on finance. Now, that's not to say, of course, that banks in the current climate, of course, or financial institutions, we should say, I suppose, in the current climate, they're very enthusiastic about financing and lending money to them. That's their business, right? But they do have to go through certain processes to make sure that this is a reasonably viable situation, because there will be, implications for them. And even though, as we've seen in land law, most, property purchases, land purchases underpinned by a mortgage, and that gives the mortgagee the right of sale on the property. But, the mortgagee is not interested in having to, to go into that unless absolutely necessary. That's obviously there to protect their interest, of course. But basically what they're happy with is if they sort out a loan with a client, and the client is a good client and just keeps repaying the loan according to the terms of the loan. That's what they prefer. So they want to make sure that's as much as they can be, they're a legitimate provider, not sort of cowboy sort of thing. That's what they want to try and sort out, in advance. And so there's detailed documentation. And so approval in principle is not that, yes, we've got finance locked up. Yep, that's right.
So this comes to the first part of the question, whether the standard terms in the contract of sale relating to finance, whether that's sufficient. The advice that I provided to Alex was that, in my view, I think that the standard conditions are satisfactory, provided he understands those conditions and completes the contract with allowing sufficient time to ensure that he does have a legitimate approval from the bank, so that he can exit that contract if he needs to. Otherwise, I did see your response to my post.
What do you think of that?
Well, whether a special condition is really required, I would argue that if a special condition is required in this case, which seems generic in terms of the finance situation, then every contract would need a special condition. I can't see anything on that suggests from the borrowing, from the finance perspective, that this is anything unusual. So to me, so long as he complies and doesn't put the date too early, he gives himself sufficient time to ensure he can comply with the bank's requirements, then once he's assured that he has that, if he doesn't have that in time, then he terminates. So
I mean, that's fine. I mean, if you there's provision in the standard form contract, as you'd expect there would be, dealing with this sort of matter. And unless there are exceptional circumstances which require a different type of provision. Having said that, of course, finance clauses are one of the standard classic areas where we see special conditions emerging because of the plethora of financial situations and circumstances under which the financing takes place with regard to sale transactions. But that has to be fully explored with the client, as you've suggested, and that's then a matter to decide based on those circumstances as to whether or not the special condition proves necessary on the one hand, or whether the clause in the standard form contract meets the situation. Yep, that's fine. Yep. Yep. What's next?
So then the second issue is with regard to he requires prior settlement of his property so that he has the funds to pay for this purchase, and the standard conditions of the standard contract do not provide any provisions relying on the settlement of an existing property. So he certainly needs a special condition, and I've provided an example suggesting that he enters a condition making the contract subject to and conditional upon the successful settlement of the buyer's existing property, that has to settle, and in the event that doesn't settle, then it's at his discretion or his choice whether he terminates the contract, and includes...
How specifically will you identify the existing property, do you think?
Well, this is actually, there are some similarities between quiz 2. In quiz 2, I included the address of the property to make it clear, because that was provided on the fact, so we had the address. In this situation, obviously through discussion, I would be getting the address and details of the property. I'll be including that so that it's clear, so that there's no ambiguity, because if he did happen to own more than one property, whether once it gets litigated and there's a dispute and he's got something else happening that he didn't want tied in with this, that could be an unforeseen consequence. So yeah, as much detail as possible to make it specific.
We've got to make decisions about that, in terms of this is a contract, binding contract expectantly with the other side, and you would decide how much specific information is necessary in a clause like that. But the point about, of course, you anticipate that the client may actually own more than one property. That's certainly a possibility. And so we've got to be, I think, as clear as we can be. If we're talking about one thing being conditional upon something else happening, well, conditional happening what with regard to what's specifically or precisely we're talking about here. Yep.
Obviously, what else needs to be taken into consideration is then what is the consequence if that event happens.
Yep.
And in this case, I've included in the special condition that all deposit monies are refunded without deduction. And again, that's where what that makes me think about is that there has to be potentially a negotiation between the parties, because that special condition obviously serves the purchaser well, but then the seller may not agree to that. The seller may want that watered down so that he can retain part of the deposit or all of the deposit or whatever the case may be.
So practically and realistically, do you think that's going to fly with the seller and the seller's representative?
I think there are a lot of environmental conditions that'll really decide that. If they're in a slow property market and properties are slow turning over, then they're probably going to accept a condition like that. If they're in a buoyant market and they have buyers, purchasers lined up that, there's somebody else who wants it at that type of price, then they're going to most likely sell it to the person who has the most convenient conditions to the seller. So they want security in selling their property. If someone comes along and says, well, I'll buy it for the same price or slightly less, slightly more, with no conditions, then they've got a very good run at getting that property.
Yeah, okay.
So that becomes part of the commercial negotiation, I think.
Yeah, that does, but that's all so a part of it as well. It's not an irrelevant consideration in terms of the negotiation process. All right, anything further? Anything more to do with it?
I think that's it.
Yeah, I think that's it.
I do have a question though.
Yeah.
From an academic perspective, when answering questions and things, obviously we refer to case law. When preparing a client advice, as much and just from personal experience in the past, I've seen and obtained legal advice that refers typically to legislation and the solicitor's opinion as to how that would apply and as to what their opinion of the law is. I've never really noticed a client advice or receiving a client advice that refers to case law. And I'm curious because just through discussions, a lot of people don't understand what the common law is. If you're referring to case law, they won't know what you're talking about. In practice, would a client advice in practice to a typical lay home purchaser include references to case law?
No, it wouldn't. Of course not. Again, it depends on the client, right? So, I mean, we discussed this previously. So that again, you've got to know your audience, right? I think it behoves any practitioner in a practical situation to be explaining, and this can be orally or it can be in writing by whatever method, through communication. Let me put it more broadly than that. Whatever method of communication that's being employed, to do that in a way that is practical and using plain language with the client, but also being mindful of the particular circumstances of the client. So if you've got ordinary folk buying a residential property, that's different to if you're dealing with a commercial business, a large commercial business. If you're dealing with a lawyer in a large commercial business, it changes the nature of how you do it. But if there are concerns that you have and there are, in your view, wrinkles in the process or whatever, this needs to be documented somewhere, and normally where this would be documented in the supporting law would be on the client file. Now, historically that was a paper thing, but today that's probably in most contexts electronically stored. So it would behove the practitioner to have that supporting legal explanation somewhere and documented somewhere and a part of the client documentation. But an ordinary client is not interested in case law or complex provisions of legislation. They wouldn't understand it, basically. That's the truth. But you do need to, and even to the extent, take one step further, they're not even, they were challenged in some clients would be challenged and also not interested in the detail of the clauses within the standard form contract of sale, for example. They just expect you to know it and to get on with it. But you have to proceed step by step, explain things to them as needed, not just because you have to, but because it's important to, and do that with plain language and do that with clarity. But also, if you are seeing that there are issues or there are concerns, then you're documenting those in an appropriate way in the documentation of the client file, however stored. And if there are issues that arise in the law and you think this becomes important to explain to the client, then you can find a way in plain language to explain that and say, look, there's some case law here that I'm not going to go into the detail because it's not necessary, but I am keeping notes on that, because there could be something that might arise because I've got a bit of a concern on this issue, but this is how I'm going to explain it to you like this, and that's the best way to proceed. But you do have to appreciate, the nature of your client. And this really much gets to the heart of knowing your client. And yeah, but it's a good question. How you keep the information about the law and how that links to what the client wants and what they end up with at the end of the day. The other thing too, which I think is nice about that, is very important to remember that there's the worlds of your learning of the law that happens here, and the world of your practice of the law, which happens out there. Increasingly, these things have to be seen as integrated. Historically, they were not. Historically, you learned the law. Well, I mean, there's been an historical sort of, evolution. So if we go back far enough, you didn't learn the law like this at all. How you learned the law was in a very practical way by learning from practitioners in practice, and you went around with them and you sat in their offices and you experienced attempting to draft things and writing letters to clients and listening, but never being remunerated for that, and just sitting in and learning, and then also at night or whenever, reading up on the law and reading up on the legal principles. So historically there was much, in my view, better interaction between these two things. Over time they became separated, so that you learn the law, learn the principles, learn the intellectual aspect of the law, if you like, I'll put it like that. And then later you did the practical bit, and then when you went into practice, it seemed like it had very little connection back to what you did in law school. I believe, and I'm supported in this by the initiatives of Australian Council of Law Deans, not because I'm saying it, because they're seeing it as an important initiative, that these things have to come back together again. Very important. And that's why I'm certainly keen to do that in what I'm doing with my students, to find ways of emphasising the connection, to find ways of testing practical application and practical skills development and aptitudes and capabilities, but grounded on good understanding of law, legal framework, thinking about underlying concepts, so on and so forth. So, yeah, I mean, that's how I'd explain it. This course, of course, lends itself very much to that sort of practical thinking about law, unlike maybe some other courses. But I think in all areas of your studies, you've got to be thinking like that. It's really important. Yeah.
Okay, thank you.
That's my pleasure. Well, that's about all. I don't want to. I think we've covered the area really. Just also, you've probably already done this, but just I loaded up that more recent Queensland Court of Appeal decision, Caprice Property and Maclay, 2013 decision. Just have a look at that in the context of this topic. Yeah, but otherwise, I think that's it. We've covered it. So, look, it's an important area, and but it's also one with good practical application, and it brings out different features of actually what we've been talking about for a while, I think, and it tests the practitioner. Just that last point, in the summary that toward the end of the notes. It's the task, this is what I say, it's the task of the skilled practitioner to carefully draft appropriate special conditions, taking into consideration the parties' intentions, the requirements and client instructions, to which now, on reflection, I might also add, and in light of prospective litigation. So that prospective mindset and context where these matters are going to come up for consideration and debate and review and scrutiny informs how we draft the clauses and put the language together at the time when we're doing that. All right. Enough?
All good at this end. So thank you very much.
All good. That's my pleasure, Grant. The recording will be posted very soon. And this being week 11, I think, according to what I had foreshadowed, I think at the beginning of the course, class participation in this course runs to its nigh in this class. So that's it. So I'll be also just sending out class participation marks in the near future, and at the very latest, probably beginning of next week, but maybe even before then. Look, thanks so much. We've got a class next week, of course. We've got a class next week, and we'll be covering the last two topics next week. And just let you say something with that. So we've now covered topic 9. And so next week, what I want to do is we're going to do 10 and 11, but we're not going to do them together, obviously. Do 10 at the normal slot. And then, are you okay for an evening slot?
Yeah, I think so.
I know you've got some family issue, like commitments and so forth, but if I give you the notice now, that I'm thinking about around maybe 7 o'clock. How would that work?
Yeah, 7 o'clock is workable.
A bit earlier was not good, but maybe I was thinking about that when I was thinking about the time. Is that right?
Yeah, 7 o'clock works for me. Sort of that 6 o'clock time slot is too difficult.
Yeah. So what I'm thinking of this is what we'll do, right? I'm not thinking of it anymore. I've got a commitment, right? So we'll do the usual slot at 2 o'clock, which will be topic 10. And then at 7 o'clock, we will do topic 11. And then I will also make some further comments about the final assessment following the class at 7. Is that all right?
Okay.
And by then I will have also marked quiz 2, so you'll have the feedback on that. And hopefully all will be good with the world. And also, the other thing is you got the clarification, didn't you, about when the final assessment is actually happening?
Yeah, in week 13.
That's right. Yes, that's right. So, again, just for the benefit of those not here, final assessment, written assessment will take place between Monday and Wednesday of week 13. And I know that I think all of you are involved in land law with me, which is an overlap there in terms of the final assessment starting on the Wednesday. But you will have had 2 days plus, so, you will have probably finished it by then and then get stuck into land law. Right, so that's what we're going to do, and that's the program as we go forward. But look, thanks for the contributions, Grant. Greatly appreciated. And you've been there right from the beginning and all the way through. It's been really good. Interesting questions, and I hope that's been value to you in terms of what we've done in the tutes. So, yeah.
Sure. No, I actually appreciate your lectures. Actually, I wouldn't call them lectures. I'd say discussions. So, but I enjoy them. That's good. That's good. They need to be. They have. I mean, if they're not enjoyable, what? If we're not, we might as well pack up our bags and go home. I reckon. That's how I look at it. The law have to find ways of trying to make these areas enjoyable, doable, interesting, and also push ourselves. It's just, that's it. All right, okay, so other things press. So bye for now. And with regard to conveyancing, see you next Tuesday. No, next Wednesday, sorry. Okay, thank you.
See you then. Bye.
Thank you. Bye.